Hey, right, guys, I'm trying to multitask right now. I'm trying to get some links ready to share in a little bit, so bear with me. Welcome, everyone. Thanks for coming tonight. If you haven't been before, the way this works is you put anonymized what if questions in the live stream chat, and we'll try our best to answer them as quick as we can. We're using the Zoom AI this week just to see if we can get it to take some useful notes. We were pretty impressed with it earlier in the week, so we'll see how that goes. So again, and I'm going to try and use timestamps to try and say which question we're answering when. So it might just help people navigate around a bit more easily. Um, so we've had like 5 questions coming from through the week, so we'll start with them in a minute. Other bits and pieces you need to know. Yeah, don't share personal data in the chat, as always. Please just ask the question as if it's about someone else. That just stops you having to put personal data out there just to actually get a question, answer to your question. Other bits and pieces. So if you're interested in this sort of thing, the rough sleeper numbers were published today, or I think they were today. That's when I first saw them. I haven't actually looked through them yet, but my guess is there's been an increase as councils stopped doing, well, you stopped, even more councils stopped doing their everyone in sort of stuff. So yeah, I might well do a video about that at some point in terms of analysing it if you're interested in that bit. So let's get on to questions. First question we've got, and I think it'd be good to spend a little bit of time on this one. So it's 19:30. So it's 7:30 p.m. Let's try that, see if the AI picks up on it. And the question is quite a long one, but it's all about councils advising people to wait for the bailiffs to turn up. So if I read it all out, there's actually 3 questions all kind of in together. So we're served a no-fault eviction, section 21 eviction. They've got dependent children. After my appointment with the council, I was advised that I need to stay put until the bailiff comes, otherwise I'll be considered intentionally homeless if I leave before the bailiffs come. Despite challenging my housing officer, who was more than unhelpful about what the policy councils are saying, council are following regarding this advice, she was not willing to clarify. Instead, she said all councils are saying stay put. She told me she will not be putting her advice in writing. I can make a complaint if I wish to, and the council's attitude towards her advice. Basically, that's where we'll leave it now. So as I say, it's certainly not the only time this is happening. So the housing officer is basically saying to someone with this Section 21 notice, stay put until the bailiffs come. And if you leave before the bailiff comes, you'll be making yourself intentionally homeless. So we've got some good news for you. It's basically unlawful advice, but we're going to go through, I thought it'd be worth just going through in detail the chapters from the Code of Guidance, where this kind of refers to, because there is a nuance to it. It's not that it's always unlawful. There's kind of a bit of a caveat. And I'm also going to share a couple of LGO decisions which are useful in terms of just showing that it is indeed unlawful. One person got £7,000 compensation for when a council said that to her. So as I say, I'm just going to bring them up as well in preparation. Getting there, sorry guys. Here we go. Right, so let's just get the Code of Guidance up first and just have a look at that. So Code of Guidance, you can Google it, it's a PDF. Although it says guidance, it's basically telling councils how to interpret the law. So it's legal. It's not just kind of do it if you feel like it sort of stuff. And the LGO uses the guidance often to actually basically recommend compensation. So here we go. So 6.35, it starts. And as I say, I thought it's worth just going through in a fair amount of detail, just so we can kind of figure out exactly, what it's saying. So yeah, Secretary of State considers that where an applicant is A, and a short-hold tenant has received a valid notice, Section 21 notice, that's basically saying, and the housing authority is satisfied that the landlord intends to seek possession, and further efforts from the housing authority to resolve the situation and persuade the landlord to allow the tenant to remain in the property are unlikely to be successful, and there be no defence to an application for possession order, then it is unlikely to be reasonable for the applicant to continue to occupy beyond the expiry of his valid Section 21 notice, unless the housing authority has taken steps to persuade the landlord to allow the tenant to continue to occupy the accommodation. Let's just get rid of this, so hopefully you see it, but better has not let me do it. Occupy the accommodation for a reasonable period of time to provide an opportunity for alternative accommodation to be found. So there's more to it. So this is just our kind of first phase. So again, Will, if you want to correct me on this, there's basically 3 sort of stages, I guess. Well, depends how you look at it in terms of the Section 21 eviction process. You get served with a valid notice, which is going to be at least 2 calendar months. When that then expires, we have this first kind of milestone, and this is what we're talking about here. So it's when the Section 21 notice has expired. And I guess what this presumes is that the council will be doing some preventative work. So the prevention duty kicks in when you have a valid Section 21 notice. You approach the council whilst for help with housing, given them reasons to believe you're threatened with homelessness, or you might be. Yes, valid Section 21 notice, and it's within 56 days. So if you think about it in terms of a calendar, because the Section 21 notice will be 2 calendar months, that's more like 60 or 61 days, depending which months you're talking about. 29 today, obviously, with February. So that's the kind. So you might have to wait a couple of days to actually approach the council technically, and that triggers the prevention duty, and that means the council should be basically doing a fair number of things. But one of the things they'll be doing is contacting the landlord, first of all, to see if they're serious about the eviction, and secondly, just to kind of negotiate with the landlord. And councils, I think, actually will use sums of money to incentivize the landlord to keep that person there longer. So that's what we're talking about here. So it's kind of fall short of having any absolutes, which is unfortunate for the guidance. Generally, the code of guidance is pretty black or white, but here we've kind of got these words like unlikely to be reasonable for the applicant to continue to occupy. So that's not particularly helpful, but we'll see a bit more about it in a minute. So yeah, council's first job is to work out, is the landlord serious, because some landlords actually aren't. They kind of do it and then change their mind, and then the council will have a conversation with the landlord to see if there's anything that can be done to kind of allow the tenant to stay longer. But assuming that's not the case, assuming that's unlikely to be successful, and there's no defence to an application for a possession order, and what sort of defences might there be at this stage? I mean, I'm not, as I say, this isn't my area of expertise by any means.
Well, there's a myriad of possible defences which have got more complicated over the last 10 years. Initially, there were very few defences because the judge would simply be asking, is this an assured short-hold tenancy, and has a notice, a Section 21 notice, been validly served? And if the answer to those questions were yes, then there'd be a possession order. But since then, there's lots of different possibilities. The failure to protect the deposit would make the notice invalid. A failure to give the tenant prescribed information about the protection of the deposit would make it invalid. And so what they did was they each year for a while, it seems to have stopped now, but they were introducing new requirements. If you hadn't served a gas safety certificate or a leaflet called How to Rent. So basically, anyone trying to defend a Section 21 note, a no-fault eviction claim, would be looking at a checklist which is on the Nearly Legal website, which Anthony Gold solicitors have produced, which is a sort of gospel, which takes you through a sort of if this then that. When did you move in? So it'll check whether any of those rules apply to you. But there's plenty that they could find. But at the end of the day, there may simply not be any if the landlord got their act together from the word go and the notice is valid.
And presumably the housing officer will be the one who's likely to be motivated and equipped to kind of ask those sorts of questions. So that's not something that a tenant is likely to necessarily have the knowledge to kind of do that. But that's the reason why it's important to go to a council, is to actually get the housing officer, because at that point, the housing officer is motivated to help you out. That changes, as we'll see a little bit later on, but that's kind of where we're starting here. So taking all that into account, landlord's serious about evicting. There's no defence. There's no issues with the notice or anything like that. The code of guidance is saying that it is unlikely to be reasonable for the applicant to continue to occupy beyond the expiry of the valid 21 notice, unless it goes on to say there's kind of steps made to kind of allow the tenant to kind of bridge the gap. So the landlord might extend it for a little bit of time because there's going to be an offer of accommodation not too long in the future, and there's maybe some sort of financial sweetener just thrown in to kind of make that kind of more sort of attractive to the landlord. I mean, in one sense, if everyone's saying the tenant's going to leave, then I would have thought most landlords would be kind of okay with that. They'd be fairly relaxed. So that's what we're talking about. But yeah, it only goes as far as saying it's unlikely to be reasonable. So quite what that means in the real world is kind of not really answered in the code of guidance. So it then goes on to a bit further on, and just to kind of bear in mind here. So this term here, reasonable for the applicant to continue to occupy. This is the definition of homelessness. You can't be intentionally homeless if the accommodation was unreasonable to continue to occupy. So this is kind of why these words are important here. So going back to our first question, which seems like ages ago now, you're not going to be or it's unlikely you're going to be intentionally homeless if you leave when the valid notice to quit expires, given these kind of three sort of caveats. Then it goes on to say, so 6.36 of the Code of Guidance, the Secretary of State considered that it's highly unlikely to be reasonable for the applicant to continue to occupy beyond the date on which the court has ordered them to leave the property and give possession to the landlord. So, as we talked about before, that's maybe 2 or 3 months down the line after the Section 21 expires. And then this final one here, which hopefully is the kind of final nail in the coffin. So housing authorities should not consider it reasonable for an applicant to remain in occupation up to the point at which a court issues a warrant or writ to enforce the order for possession. So I'm guessing that's the bailiff warrant, right? And then it kind of does it in bold. Housing authorities should ensure that homeless families and vulnerable individuals who are owed a Section 188 interim accommodation duty or Section 193 main housing duty are not evicted through the enforcement of an order for possession as a result of a failure by the authority to make suitable accommodation available to them. So this is kind of our, so quite what kind of makes this unlikely, or kind of what circumstances this wouldn't be the case, is not really explained in the Code of Guidance. But certainly once you get further down the eviction process, it is very, very clear indeed that first of all, housing authorities should not be telling you to wait until the bailiffs, or not, not helping you until you get the bailiffs kind of knocking on the door. And probably, long before that, you kind of there's this kind of the council should be stepping in. And crucially, as I say, you're just not going to be intentionally homeless if you leave that property at that point. As I say, Will, I'm kind of looking at you because you deal with this more often. What sorts of situations do you think where would it be reasonable to continue to occupy over past that date? I mean, as I say, it doesn't really spell that out, but I'm not quite sure where it would come in.
I'm thinking about this in terms of, I mean, I can't think of many situations where it would be reasonable to continue to occupy past that date. And because, I mean, what we're saying is you really want to avoid being physically evicted, and also put through the stress of possession proceedings. So, I mean, I suppose from the reason, I mean, I would say that reasonable is a lawyer's favourite word, because it really doesn't mean anything, and lawyers can spend all day arguing about what it means in a particular context. From a council's point of view, it's reasonable for them to stay there until the bailiffs come in, because then they won't have to house them. And from the tenant's point of view, it's reasonable to be housed as soon as possible, because they don't want to have to go to court. But I'll tell you what I was thinking on this is that if you look at the wording of the definition, sorry, the Code of Guidance is a little bit unclear as to whether you are actually entitled to be provided with temporary accommodation at this point. It's saying that they shouldn't be required to do this, and they may be, and they should be treated as threatened with homelessness, and they're saying it's unreasonable to continue to occupy. But they don't actually say you should treat them as homeless and your duties under Section 188 will kick in. But, I mean, sorry if this is obvious to everybody, but the definition of homelessness at Section 175 of the Housing Act 96 includes at subsection 3, where somebody is living in accommodation which it would not be reasonable. Well, they won't be treated as having accommodation if it's not reasonable to continue to occupy. So you could interpret that part of the Code of Guidance, which we've got up on the screen there, as meaning that they are actually already homeless. Because if it's unlikely to be reasonable to continue to occupy, you can say, well, I'm homeless then, and therefore you owe me a duty under Section 188. So if the council said to you, at this stage, we're not going to give you temporary, you could judicially review them and say it's a fairly open goal that they've failed to discharge a mandatory duty, as if you're in priority need.
Yeah, so I 100% agree with that. So the report we referenced maybe last week, where Bedford Borough Council had commissioned this report from these experts, and the report was basically saying that the council shouldn't be issuing temporary accommodation when the notice expires. And the stats said that in the majority of the cases, the council was accepting temporary accommodation duties at the point of the expiry of the Section 21. Now, in one sense, if you read it like this, so it's unlikely to be reasonable, well, therefore you'd expect the majority of cases to result in temporary accommodation being offered. Then one situation which is not uncommon to arise actually is where the homeless application has been triggered, and the applicants would rather stay put in their own accommodation rather than move into TA, because in one sense the time is already ticking by that point. So you're not going to It's not going to delay the homeless application decision down the line if you were to remain in your home. And so some people would be, they'd rather stay in their own home than to move into TA for another 2 or 3 months or whatever. And certainly councils would be, they need to tell the applicant that they would potentially risk getting court costs, which are about 350 quid or something, if they remain. But councils would be sensible to actually pay that themselves and say, hey, do you know what? If it's okay with you, are you okay to stay in your property until the bailiff actually comes knocking, or goes down further down the line? And if and only if they're genuinely happy with that arrangement, which they could say they might be, then I think that would be something which you wouldn't be able to complain about. But certainly a situation where the applicants are saying, no, we need out, we don't want to have this stress, this additional stress right now, then I agree with you, Will. The section 108 has been triggered because there's reasons to believe that it might not be reasonable to continue to occupy the accommodation in effect. So if that's our kind of just a start point, I just want to add in a couple of LGO reports, and when I'm really clever, I'm going to share them into the chat as well. So there's two. I've brought up two here. So basically, this one here, and this was made worse by COVID, because COVID hit just so it started off just before COVID, and then that resulted in them being kind of left in accommodation for ages. Now I'm not going to read it all out, but so if we go down to the bottom, it's the quickest way is to go down to the bottom, because it says what actually happened. So agreed action. You can read it all yourselves when you get the link. But so the council should take the following action to remedy the injustice. So give her a full apology, pay £500 for each month she remained in the tenancy. Now, because of COVID, it'd been, however many months that had been, like 14 months or something. So that's why it's £7,000. £355 to cover the avoidable court costs, and another £250 in recognition of the unnecessary uncertainty. And it's also recommended the council take the following steps. So issue a reminder to relevant staff of the council's duties under the HRA and provide any necessary training to new staff. So review and amend the council's policy on when to make an offer of Section 108 interim accommodation in line with the law and guidance, and review all current cases where the council's practice of requiring applicants to wait for a possession order and bailiff warrant might result in similar fault. So you can see the LGO is kind of where the code of guidance kind of falls short. The LGO is actually really helpful here, because if we go back further up, it sets out what the law is somewhere, usually does anyway. Yeah, so here we've got, so this is kind of how to interpret the law. So we're not going to look at it now. So that's one of the cases. Then another case was interesting from the fact that it was the landlord who got compensation. So the landlord basically complained that the council had advised the tenant to stay put. That resulted in them losing 1,100 odd pounds in rental income. So they got that money back, and they got £100 for the time and trouble of, I mean, that doesn't really cover the time and trouble it would take to go to the LGO, but that's just an indicator of kind of how this works both ways. And again, you've got statutory guidance, so it's all helpful stuff. So in a second, once I've kind of finished this, I'll stick those links into the chat and the description of the video, but they're well worth reading. So this is a really good example of how the LGO will kind of expand on what's in the code of guidance. So yeah, hopefully that's helpful. I might end up doing kind of a dedicated video about that, because it's just something which is coming up a lot, it seems. It's truth. I've just seen the live chat. So how you right, Nick? So let's get to some of these questions. And again, if I just remind people not to ask questions about their own situation, but instead ask the questions if it's about someone else. So is someone required to give the council their abuser's details? In the dash form, there is a section which includes the abuser's details. So good question. It's not something I've thought of before, but let me just kind of, I guess, give my initial thoughts, and then Shannon and Will surely fill in the gaps. So first of all, so the dash form is the domestic abuse, stalking and harassment form, and it's kind of like a scoring chart. And the idea is it's supposed to work out kind of what kind of risk you're at from the abuser. And as this question has said, yeah, it does ask for details of the abuser in there. Now, there's nothing. I think my initial answer is I think there might be situations, fairly unusual situations, where the abuser, the victim might be so scared and so fearful that they really don't want to give that information to the council. Now, dash form is just one way that they might do that. They might also give it to the officer in the homeless application process, or a safeguarding inquiry, or children's services, or whatever. So there's nothing that says they have to. But I think in most cases, the kind of the assumption would be that they would kind of disclose that information. I guess it's important to say that the council would need to explain to them how it's going to be used. This is why data protection stuff is actually so important, because the council will be able to say, okay, this is how we'll use this data. This is where it is going to go. This is where it's not going to go. This is how we're going to keep it secure. There's stuff in the code of guidance, interestingly, which talks about how, because councils are quite large organisations, there's a real importance to protect information from other colleagues, and so it's only seen by the people who need to know, because it's not unusual for employees of the council to have connections to the perpetrator and therefore disclose information. I've certainly seen cases of that before and similar sort of things as well. So I think if someone was to refuse to give the perpetrator's details, I guess the council need to deal with it very sensitively and need to kind of, on the basis of the facts, try and assess why that might be, and it might be legitimate. Again, default position of council should be to believe people who disclose they've been abused. So that's the kind of starting point. But I think the council just would need to be very careful. But I think it's entirely reasonable for the council to certainly ask and reassure them that the information will be kept confidential. So yeah, I don't know. Have you guys got any thoughts about that one? It's an unusual one, Shannon.
I think to add to that, I think if you sort of think about it, the fact that you don't need evidence of domestic abuse to approach a council for help with your housing, arguably you don't need a dash form. So actually, if you've got a client who's willing to fill in the dash form but isn't able to fill in certain bits, and the person who's asked the question has elaborated, which I think shines quite a bit of light onto why you wouldn't want to elaborate, then actually that should be okay, because your starting point is that you don't have to give any evidence. And particularly in these situations where evidence is likely to be unavailable, I think that's what I would sort of, if I was being questioned on that, that's the sort of like comment I'd give back. And I think they've then gone on to talk, ask around the housing details. So again, I would sort of say the same. It's a bit difficult because if you're fleeing the address and you're fleeing the abuse, obviously you do give your last settled address. But at the same time, you're not explicitly disclosing which parent. It might be both, it might be one. But there's nothing to say that you have to do that. But it's just that you would have to give the address. But I don't think you would have to then disclose which person, and it doesn't matter who's on the tenancy in that address. Person doesn't have to be on the tenancy of that address to be abusing you for you to be fleeing and already homeless. So yeah, I don't, and yes, the council will absolutely still help the victim if they were still living there. Have a duty to help them. So yeah, they can make a homeless application and should be provided with temporary interim accommodation straight away, because it is domestic abuse and it's an automatic priority need.
Yeah, thanks, Shannon. I'm just trying to dig out the bit in the code of guidance which talks about, it doesn't exactly apply to this, but it kind of, where is it? It might be yeah, let's say this might be kind of, this might where we're going. So this might kind of help out a little bit. So this is 21.24, the code of guidance. It's a long one, but so housing authorities may wish to seek further evidence where it's available and appropriate to do so. It is essential the inquiries do not provoke further violence and abuse. So it's still using, I don't know why it's still using violence. It means abuse every time. I don't know why it says violence and abuse. It's a weird one. But housing authorities should not approach the alleged perpetrator, since this could generate further violence and abuse. With consent from the applicant, the housing authorities may, however, wish to seek information from friends and relatives of the applicant. So blah, blah, blah. So housing authorities are not required to attempt to gather evidence from all the above parties and should contact only those that judges are best able to provide supporting evidence. And housing authorities should seek consent from the victim before approaching family or friends, as the abuse may be experienced with multiple. Yeah. So I think, I know this doesn't quite answer it exactly what the question is saying here, but I'm hoping that's helpful. And I think when you're making that homeless application, I'd probably quote this paragraph of the code of guidance, just say, look, this is a really sensitive situation. The officer's dealing with it. First of all, you can ask for an officer who's actually had training in domestic abuse. You can ask for an officer of the same gender. These are things good. And just, yeah, I'll just say this because this is a really good one anyway. So housing authorities should not have a blanket approach towards domestic abuse, which requires corroborative or police evidence to be provided. So So again, it's just kind of making sure, that kind of goes back to what the LJO said, that the default position is to believe victims. So yeah, I mean, there might be some more stuff in Chapter 21 of the Code of Guidance that might help you out, but I'm hoping that kind of gives some kind of indication of how these inquiries should be done. They need to be super sensitive, and they need to not make it any worse for the victim. So yeah.
I think the person in the chat's just clarified as well, is around sort of the housing details about like what type of tenancy and stuff. I mean, look, there's a practical point here where the more honest you can be with the local authority and the more honest you can be with the housing options officer and that whole process, the smoother it will probably go. At the same time, there's a protective element of protecting yourself or the client, and then like there is a balancing act there. But again, for that point, I'd say the blanket approach is really important. If they're not accepting your homeless application because you can't give the type of tenancy it was, that's not legal.
Yeah, I think having read a lot of LJO reports, I think the LJO would say, well, it's absolutely reasonable for the council to ask, and I think you basically the default would be to the individual would need to explain. They couldn't just kind of sort of just not say anything as to why. They need to give like a reason, explanation of why they don't want to give that information. And it's possible you might be able to get the information that the council needs without doing that. But I think, yeah, I think as I say, yeah, I'm not quite sure is my answer, but I think certainly it needs to be done very sensitively. And then there may well be situations like this where something comes up where they genuinely would make things worse for the council knowing that. So it is something you can go into a council, as I say, and kind of insist that they deal with it competently from the start by having trained officers dealing with it. Because we've said elsewhere, loads of housing officers haven't had any training on any of this, and can just be make things 100 times worse. So you can absolutely kind of go in sort of tentatively, and then hopefully the housing officer shows himself to be trustworthy, and then the individual would give the information that they require. Hey, Andrew. So cool. Right, where are we up to? So someone private rented 2 beds with 4 kids and husband. I'm assuming one kid is 19, and the others are 3, 6, and 8. So hold on, where's the actual question? So the council's saying that there's a lack of 1 bedroom, and lack of 1 bedroom is not overcrowded. So I guess, and I can't do the maths in my head here in terms of whether it sounds like it's overcrowded, but as we said elsewhere, that doesn't necessarily help you. So it might give you like an additional point on the housing register or something, but it won't make you homeless. So therefore you won't be able to make a homeless application. There's also questions like, are all the household members eligible for assistance? Because if they're not, then they're kind of treated as invisible as far as I understand it. Shannon?
It's also just things like if you've got a living room, then that should be treated as a bedroom. So actually you might be in a 2-bed house, but actually for the purpose of the sort of workings out, you'd be in a 3-bed, and then which children can share with which. And then, like you said, the comparativeness of the local area. So yeah, because obviously you've got like the room standard and the space standard. So it's quite likely that you might be overcrowded, but not, like you say, homeless because of that.
Yeah, cool. Okay. So next question. It's just someone basically asking about where a council is being reluctant to prevent antisocial behaviour, and also there's issues around the home being unfit for human habitation, forcing the tenant to seek alternative accommodation, sewage, flooding, damp and mold, threat of ceilings caving in. So this is certainly something the council needs to deal with. Now, I guess with antisocial, it's just antisocial behaviour. It's worth just saying that the best will in the world, the council's not necessarily actually able to do anything useful. It eventually it might be able to do something, but it's going to take a long, long time before the council can actually take steps to prevent it happening. Will?
Yeah.
Or you just cool,
sorry. I mean, this is one of those issues about sort of rehousing or accepting a homeless duty versus prevention duty, isn't it? And I'm assuming maybe the council is the landlord here, but if not, Because if somebody's subject to antisocial behaviour and they're living in unsuitable accommodation, then they're homeless. So the question, what if the council are reluctant? Then well, the council would have to rehouse them. But the suggestion here is forcing the tenant to seek alternative accommodation means that maybe they don't want to be rehoused. But the question is, how much could you require a council to do to prevent the person being homeless? And I think it would be quite an uphill struggle to say, I want them ordered to sort out all the antisocial behaviour that's been, and also put the property into a good condition. So it might be better just to get rehoused. But I'm sorry if I'm missing something there.
Well, I think so. Environmental health certainly sound like they need to be involved in terms. I think I'm not a lot of experience at all going to environmental health, so there's probably a lot of things I don't know here, but certainly one of the things you could be doing is taking pictures of everything that there's a problem with. So particularly if there's sewage and stuff, then taking a picture of that, writing to the environmental health team in the council and copying in your councillors. It goes back to this whole idea of involving your local politicians who represent you. And let me just get off the code of guides for a second. There we go. Yeah. So I think that would be something you kind of potentially want to do. I've seen it before where the housing team will kind of argue with the environmental health team and work out whose job it is to actually deal with it. But as long as one of them's dealing with it, it doesn't really matter. And copying in your councillors and your MP will be a good way to make sure they don't just play tennis with your case and actually pick it up. So yeah, I mean, again, I haven't seen it happen in any detail, but a council can basically order the landlord, or if the council is a landlord, even better. But if the council can order a private landlord to carry out works, and so yeah, and kind of potentially prosecute and stuff eventually, although that doesn't seem to happen very often. So there are things that the council should be doing. If the council simply just being slow about it, don't be slow to complain if they're delaying. And as I say, photographic evidence is really, really like it speaks 1,000 words, as they say. Sending photos of what's going wrong in your property to the council with them, those people copied in, is going to make a big difference, I'd say.
Am I right in thinking, so if it was like affecting their health in like a serious way, so making that they were homeless because of the effect on their health, then the council might not end up like rehousing them, but they would have to provide interim accommodation whilst the issues in the property was being fixed.
Yeah, I mean, yeah. So I think there's reason to believe they might be homeless from maybe more than one avenue. So I would have thought anywhere where there's sewage flood, any sort of flood of sewage, that's something which, and it's not reasonable to continue to talk about that property. Same thing with the threat of ceilings coming in. Now again, it's a case of how do you know that? Cracks in the ceiling doesn't mean it's going to fall down. Has there been some kind of survey done on the property? I've seen cases where the environmental health have found category 1 and 2 hazards in the property, and that's kind of eventually been enough to get the housing team to kick into action. But yeah, Shannon, you're absolutely right. Legally, if there's reasons to believe you might be homeless, might be eligible, might be in priority need, then they need to make accommodation available. And as you say, that might be whilst they're carrying out some works or getting the landlord to sort things out. But yeah, I think, as I say, I'll kind of go back to what I said about just involving politicians. I think that's going to be the thing which probably gets their attention and gets some sort of action.
Just a follow-up question, and I know this isn't a space for me to ask questions, but so in that, if that was to happen, who would be liable for the rent in that case? Because I've seen it before where people have got into some like real difficult situations where they've been asked to leave their property, they've been put into temporary accommodation, and then they're essentially liable for rent still, even though, and then it just becomes tricky. So how, like, any advice on around that, I guess, for people?
So that fits neatly with a question we had coming in through the week where it's the same issue, but it's a different scenario. So I might as well say that. So it's 8:03 p.m. if the AI is following us here. So the question that came in the week, as I say, it's relevant here, is that someone is in full-time employment and was homeless and was basically told, here's a B&B or a hotel or whatever, it's £60 a night and you have to pay it all. And it was just simply unaffordable for the person in work. Now, same kind of principle when it comes to providing temporary accommodation. It needs to be affordable. It needs to be suitable. That's the kind of way the logic of it. All accommodation often needs to be suitable, and part of that suitability assessment takes into account the person's finances. So in the case where you're potentially paying two rents because you're being decanted into another property and paying, liable for two rents, that doesn't mean to say the council shouldn't be paying whatever it takes to kind of make it affordable for you. May not be the full rent potentially, it could be just a lot less than that. But yeah, I'm just also thinking about starting the complaint process now, because this is something that probably needs to go to the housing ombudsman. So the local government ombudsman and housing ombudsman are two different organisations. Both do a similar thing, but the LGO, the local government ombudsman, looks at local authority actions basically in certain departments, including housing and homelessness, and the housing ombudsman looks at. I always assumed it would just be social housing, but I don't know if it does anything around private renting as well. I'm not sure actually, but yeah, so the housing ombudsman would potentially be useful, and it's something you could ring them up. They won't be giving you particularly detailed advice, but you could ring up the housing ombudsman and say, look, this is my situation, what should I do? And they'll probably say, start the complaint process now. So going back to your council, just complaining about it, copying the councillors, and hoping that kind of sparks some kind of action. Yeah, anything else to add to that one?
No, I mean, I suppose the strict legal answer is if the person goes into temporary accommodation and they're paying rent for that, then they're going to, and they can't pay the other rent, then rent arrears are going to accrue. If the landlord of the property that's in a bad condition was to take action to recover the rent arrears, the tenant would arguably have a good defence to say, well, I wasn't able to occupy the property because of the condition it was in, and therefore I should counterclaim for the value of the rent, and put in a defence along those lines. If the landlord is the council, oh yeah, look, I know how. No, sorry. I mean, maybe the person putting in the questions about this could clarify. If the landlord is the council, I'd have thought it would be pretty likely that they won't claim rent for the two properties at the same time, because they'd have to admit that they had failed to carry out their duties to maintain the place. But perhaps they could say whether it is a council property.
Yeah, the inference is I think it is actually, which is even it makes it even worse really. It's not that surprising when private landlords don't kind of don't do what they should do, but it's pretty sad if council landlords are also not doing that sort of stuff. So I feel like I had something else to add to that, but I've now forgotten it. Never mind, it'll come back to me. Yeah, so cool. Right, let's just see where we're up to. Let's take another question from the live stream. We'll go back to the questions from the week as well. So I don't think I missed. I think yeah, okay. So question about intentional homelessness. So it's now 8:06 p.m. So the question is: councillor found a lady intentionally homeless, 3 kids with her mum in a 1-bedroom bungalow. Children's services have completed assessment and found the children aren't in need. Okay, so I have a feeling this question came up maybe this situation came up a couple of weeks ago. So you've got a situation where the family have been found intentionally homeless. They've then moved into the grandparents or the grandmothers or whatever 1-bedroom bungalow. So that's 5 of them living there. And children, and I think what we said back last time was, get children's services involved and get them to assess. And what they're saying here is that they've assessed and said the children are not in need. Now, I don't know I know very little about the detail about challenging the Children Act stuff, but that doesn't sound to me like a very, that assessment doesn't sound like it is that robust. So I don't know. I don't know if there's anything that's kind of mirrors the housing decisions you get, but I don't know if that assessment it says, if you want to challenge this, then this is how you do it. Yeah. If I might ask this question in our Facebook group to see if any social workers in the group would sort of have an opinion about that and whether they can be challenged. But yeah,
my experience is the only way to challenge a decision like that, other than a formal complaint, would be through judicial review proceedings. And I've been involved in quite a lot of judicial review proceedings regarding Children Act assessments, and the tendency to find that children aren't in need is quite strong. And you'll get situations where they'll say, oh, they're not in, they might say they're not in need because things aren't as bad as you're making out. Or they may say, we simply don't believe you, which is really bad. I had a case once, won't go into too much detail, but you can see the sort of thing. What they try to do is make out that this, particularly in the case of migrants with no recourse to public funds, they'll say that these people all have a secret source of income and they're just trying it on. For some reason, they're all trying it on so they can get put in B&B and hostels, which has no particular value. You can't sort of sublet it. But there was one poor family that the mother had been working before she lost her job and then became sort of destitute. And while she was working, she bought the child an iPad. And they'd said the child can't be in need because the mother's rich enough to have bought an iPad. And the point was, well, she bought it ages ago. And so you've got to look at it now. But it's that sort of deliberately stupid decision making where they'll say, well, let's just see if we can get away with it. So, yeah, I mean, do try and challenge it. I don't know what the facts were there. I mean, they may be saying, well, you're okay at the grandparents, because they may have persuaded the grandparents to let them stay, say, oh, yeah, they can stay as long as they like, because they've said you don't want to see your grandchildren on the street, do you? I don't want to be mean to social workers who may not like me saying this, but there is an awful lot of bad faith stuff goes on in Children Act assessments. Not usually the social worker, it's often the manager. They'll submit an assessment to the manager, and the manager say, no, change that. You can't accept them. You can't accept them as being in need because then we'll have to pick them up.
So I'm going to try to remember
plan.
this week to speak to a couple of social workers I know to just to get their kind of first thoughts about that, because yeah, so I'm sure it's challengeable. But whether there's some specific case law or kind of helpful kind of guidance on that might be helpful. But yeah, I mean, yeah, complain. I think that's we agree that's definitely worth doing right now.
The trouble is, it tends to turn on the facts of each case, because the principle being involved is usually irrationality. That, if you say that a child is living in conditions which are appalling, and then you say, but they're not in need, their well-being isn't at risk, then that's irrational, that no reasonable person could reach that decision. And that's really what you're up against with most of these. But it's not, believe it or not, the decisions are often so bad that irrationality can be used.
Would there be value in kind of gathering evidence from, say, schools, or kind of,
oh yeah,
kind of just evidence the fact that the kids are clearly just kind of having a tough time, and might be a
definitely. I mean, we have to
deterioration
do
at school.
that. We have because often the schools are the main place where the kids get sort of support, and it varies from school to school. Some head teachers are very unsympathetic, although most of them are very. We had cases where the schools were paying money to help the children pay for B&Bs when the council were refusing it. We had a case where a social services department was sort of literally trashing the head teacher in court, saying this was an arrogant, dishonest person when they put in a report. So you can see the level. But yeah, the schools are a really good source. Health visitors. And schools often have a welfare officer who is a good person to speak to and get a report from.
Yeah. Okay. Yeah. I mean, hopefully that's helpful for the time being. But say, if I can try and get a bit more detail this week, I'll share it. So we need to talk about next week because we've got the event next week. But I don't know, either Wednesday or next Wednesday or Friday we'll do a live stream anyway. But yeah, cool. All right. So this question I think is about suitability of temporary accommodation. So it's 12 minutes past 8. So during the assessment stage, does a council ask for health conditions to accommodate health needs, i.e. having bladder problem where you're going to be toilet 50 times a day? So not really being able to live somewhere with shared facilities. And does the council accept health conditions that have not yet been diagnosed with medical checks or under review? So some good questions there. Okay, right. I've been reading about this a little bit this week. So with a lot of things within housing law, you need to raise the issue. So when you approach a council, you need to be the one telling them what the issue is, because I guess the default is they can't be blamed for kind of not making inquiries if they just didn't have anything reason to think that might be an issue. So you need to spell out what the issues are. When it comes to disabilities, though, the default goes the other way, and it's once you tell the council you have a disability, the council need to be really kind of proactively inquiring into that and working out how assessing that health issue and whatever else. So I think first thing is make sure you've told the council that you've got the issue, hopefully with some medical backup. But as the question alludes to, does the council accept conditions that have not yet been diagnosed. Well, yeah, again, it's not that they can only look at conditions that have been diagnosed. There are a lot of conditions, and this is something we cover in our training actually. So there's a lot of conditions which are suspected for a long time before they're actually just diagnosed. Something like fibromyalgia or Huntington's chorea or something like that, where you'd have reason to think that the person has the condition because of the way they're presenting, but you don't have a diagnosis yet. And housing officers need to treat what's the presentation. They don't need to kind of wait for a diagnosis for it to be real. But often I think that's probably what we see in the real world is they'll say, oh, you haven't been diagnosed, so it doesn't exist. So you can challenge it for sure, but I think it's probably not surprising if they try that. And I guess go on, Shannon. Yeah.
No, I was just going to add to that as well. Like the definition of a disability again doesn't matter around a diagnosis. It's long-term and substantial negative impact in your day-to-day life. So that's still very possible to have a disability and not have a diagnosis.
Yeah, and so in this respect, if you haven't already in this situation, ask for a Section 9 assessment under the Care Act, because it's possible you might have care and support needs. If you've got a kind of bladder issue or something that they can certainly assess. Whether or not they kind of have to do anything about it is another thing, but that assessment in itself can be useful. So in fact, one of the case studies we use in the training is literally where someone is presenting saying they've got fibro, saying they've got mobility issues, but there's no diagnosis from the GP. And in that case, what actually happened was she fell down the stairs. Paramedics attended, did a safeguarding alert for self-neglect, and that resulted in a social services assessment, which was really helpful when it came to evidencing it to the housing team, because there wasn't a diagnosis. But then the social worker was saying, "Yeah, I've seen this person. They do struggle with the stairs." That was really helpful. So if you had an assessment from social services or even just something from your GP, just to say, "Yes, these are the presentations. This is what we're waiting to hear back on," but it does appear to be a real thing. That's going to be helpful. And then it goes on to say, is there an act or a piece of legislation that can be mentioned to challenge it? So yeah, there is, but not. I can't think of one that's directly like this. But just going back to a lot of kind of areas of housing law, there's kind of like the council accepts something might be the case, then it waits until it's fully assessed it to actually establish whether they are satisfied it is the case. So priority needs a good one, temporary accommodation. So if there's reasons to believe you might be in priority needs, as part of the test, then you put into temporary accommodation whilst the assessment goes on, and then months later potentially they might get the results back from the medics or something and say, yeah, do you know what, we're actually satisfied you are in priority needs. So I think that's a general kind of principle that underpins housing law. So if you're saying I have a condition, it's currently under testing and it needs me to go to the toilet 50 times a day, then they should take that seriously. Now the bad news I've got with this one is I don't know that in itself, the fact that you've got to use the toilet 50 times a day, I've seen cases where that doesn't necessarily mean that it's unsuitable. So there was one involving housing reviews limit I read not too long ago, where there's, I think, someone with diabetes and then it required them to go to the toilet a lot. And, it went to court, and eventually, kind of the client lost because, it still wasn't enough to make it unsuitable. So I think generally, as a principle, you don't have to have a diagnosis for it to be real and to be dealt with properly by the housing team. But in this situation, I don't know if that's enough to actually get you self-contained accommodation. But it's all you can do is basically push for it, get as much medical information as you can, and kind of just make sure you're raising it. Anyone want to add anything to that one? You're going, Shannon.
Yeah, just so 16.7 for code of guidance.
Hold on, let me get it up.
Yeah, that'd be perfect. And then I have to multitask with my screens. But
so 16. What? Sorry.
16.7. Potentially not hugely helpful at the sort of interim accommodation stage, but it is potentially helpful when looking at that final sort of offer of accommodation. And when you're doing a personalised housing plan, it's sort of saying, there that the council should take into account any additional information from health and social care services or other agencies providing services to them. Now, depending on what you're going through, depends on which agencies you might be working with, but they do sort of have to consider whether you've got any support needs as part of that process. And that will essentially affect what accommodation you could be offered. But like Mike says, even then it still might not affect. It just depends on,
Yeah. Okay, cool.
Maybe I just
Yeah,
chip
yeah, go
in
for it. Yeah.
I mean, I'm sorry if I sound like the voice of doom here or doom and gloom, but I think that if you try to ask the council to accept that you have a medical condition where there isn't a diagnosis, you're very likely to have the council say, sorry, we don't accept that you have that medical condition. Because, I mean, arguably anyone can go to the council and say that they've got a medical condition, and it may not be, it may or may not be true. But if you have I'm not sure quite whether I'm missing the point of the question, but if it hasn't been diagnosed, arguably it's not been identified yet. But if medical checks are under review, then presumably whoever's initiated the medical checks may have a suspicion. But if we look at this particular case, we're talking about somebody who is needing to go to the toilet every half an hour, day and night, and that's 50 times a day. That works out was 48 hours, 48 times would be. Anyway, I think I got my maths right. But also, they've said that the person can't control their bladder, so that if they may need to go to the toilet, but if they're queuing to go to a toilet in a common area and there's a couple of people in front of them, they may end up wetting themselves. And that would definitely be unsuitable. And presumably, you'd only need to produce evidence that that had happened. You don't really need a doctor to say this person's incontinent if you've got evidence saying that it's happened. Unless you, I mean, I wouldn't put it past some council staff to say they did it deliberately.
So
Anyone can do that.
yeah,
But you really do need to engage with the doctor. But I thought if you've got a condition like that, hopefully you've spoken to the doctor about it. I mean, the problem is maybe there's not a lot a doctor can do. I mean, I don't know what, as people get older, they tend to need to go to the toilet more. But I'm not a doctor myself, so I don't know what, if you went to the doctor and said, I need to go to the toilet 50 times a day, whether they'd say, I'm prescribing you these. I mean, does anyone know?
I think it's the time of tests. So my experience with NHS anyway is that there's long waiting times for their brilliant work. But so actually you could go to the doctor and the doctor says, yep, you've got this. We need to do something about this. But then it might be a 6-month waiting list before you get seen by anyone, or it might be 3 months before you're able to have a test that diagnoses the thing, or you might have, a trial of medication or whatever it might be. So I think it's quite likely that the doctor would believe someone and like start their investigations, but in which case, I've mentioned the NHS app quite a lot, but like you can see referrals that your GP's made. So if you've got a GP and you're waiting on a diagnosis, but you can see that they've referred you to urology, for example, and it might have nothing to do with that, but just using it as an example, then actually that should be enough to be like, look, this is a condition. This is what's happening. Here's my GP notes from my last appointment. Here's a screenshot of them. But yeah, I think it's just timings.
I would just add one thing. Obviously, the diagnosis is a relevant term. It's a relevant, a relative term. So when the doctor decides to make a referral to a consultant, that's based on a provisional diagnosis. So you could say there's already been a diagnosis. Because if the doctor, I mean, it sounds like one of those doctor jokes, but if you go to the doctor and say something which is ridiculous, like I don't know, I've got bubonic plague or something, and they say, no, of course you haven't. I'm not going to refer you because you've been here every week saying something crazy for the last few weeks, for years. But short of that, if you say something that's conceivable, the doctor would make a diagnosis, and so you could then get the doctor to say, yes, this person's presented with this condition. I'm sufficiently concerned about it to have made a referral. I think that would be enough. You don't need a sort of Harley Street consultant to
I think I'm just, yeah, I think I'm just kind of putting together a few other kind of principles of how councils need to deal with medical evidence. So there's this kind of idea of fairness that's supposed to be seen within council decisions. So if you're saying I've got a diagnosis, and the council is then really on the council to write to your GP, and if the GP writes back saying, yeah, do you know what, referred to urology, we're kind of waiting to hear back, all that sort of thing, give some as much detail as possible, then it would be very difficult for a council to dismiss the case. for the AI, it's 8:23 p.m. and Mike is going to find this case out for next week. He's going because there was a case I read very similar to this, and at some point, there was mention of like kind of, I don't know the technical terms from sort of adult nappies. That was kind of, so I think housing officer mentioned adult nappies as kind of a way of dealing with it, and I think that was knocked back by the judge. But so I'm going to try and come back next week with the case that I read. I found it somewhere. I'll find it. So yeah, but yeah, hopefully there's some interest, yeah, some useful stuff in amongst that. Sorry, we can't be some more clear about it. Next one's a quick one. So council took 2 years, 3 months to accept the main housing duty. The first stage response, the council responded, "There's no defined time limit on making decisions on homeless applications. Is this factual?" No, that's factual. I think I go so far as saying that's factually incorrect, just to say the least. I mean, yeah. So first things, the first stage complaint is always going to talk nonsense. It's basically the housing manager, and their job is to, first stage. It's almost like they've got a policy. I don't know if it's actually written down. Is whatever they say in the first stage, just dismiss it basically. So don't worry, don't be knocked back by that. Um, so uh, so the code of guidance, and we're assuming we're talking about a case that has happened since 2018. Basically says that you make a homeless application by asking a council for help and giving them a reason you might be homeless. They then take a couple of days or whatever to establish that you are indeed homeless and you are indeed eligible. You've then got 57 days before they should be issuing the the final decision, which might be main housing duty. And it says in exceptional cases you might get another 3 weeks. So we're talking about maximum really of 11 weeks from the point of being satisfied that you're homeless and eligible. So let's say that's 12 weeks from making the homeless application at an absolute outside. So if you go to an LGO, just keep going with the complaint. You're doing exactly the right thing. Don't worry that they're just talking nonsense. Just go to stage 2 and say that's nonsense. 2 years, 3 months is way too long to reach this decision. I want some compensation. Now, if you go to the LGO guidance on remedies, let me just search for that now. So let me bring it up. Unhelpfully, they don't have a PDF version here, but let me just see if I can find so let me just share my screen so you can see what I'm doing. So I've just Googled LGO guidance and remedies. What's going on here? Come on. So you come up with this page here. So something like there's like some generic ones. So there's some really useful stuff here if you want to kind of just just learn how to make a good complaint, basically. So there's where is it? So there's something about there's specific stuff here that would help you out because it basically talks about even things like there's elements of the compensation you get. So you kind of get like £250 for uncertainty and distress or whatever and things like that. Now 2 years, 3 months, you might get a bit more than 250 quid for that. But yeah, so just kind of have a little dig around this document here. And let me just put it in. Oh, yeah, I'm gonna have to put the chat afterwards. But yeah, so I'll put it in the description of the video when this video is finished. So I'll put those 3 links in just for you to have a look at. But yeah, have a look at that. Basically, you're in a situation which is pretty standard. Council just basically acting, I don't know, indecently as a way to try and prevent you getting compensation. So yeah, keep going. You're on the right course. It will take many months more though, by the way. So and also if councils delay in getting back to you in their prescribed time limits for the complaint, then you can complain about that as well. So yeah, escalate to stage 2. Short answer. So cool. Right, let's go back. We're nearly out of time. Let's just go back to the questions from the week. See what we've missed. That's the wrong document. Hold on. Confusing myself here. So we've done a couple of them. It's now 8:28 p.m. So we've done the one of the bailiffs. We've done okay, so there's an element of that we didn't actually get as far. So if you make an application to one council, but you would rather, you've got local connection in another area and you'd probably rather live in that other area, then there's nothing stopping you applying to other area now, you can make simultaneously applications to more than one local authority, and hopefully your second authority is not going to say something stupid like wait until the bailiffs come. So yeah, so do that. Make an application to the second local authority now with the same information. You know, you have to be honest about the fact that you've approached the first one, which can cause some issues. But that, yeah, that's that legally that's the answer. Practical terms, you might need to throw a couple of complaints in there to get them to do the law.
Would you not be better off asking the first local authority to transfer you to the second local authority, or do you think you'd be better off making a fresh application? Because I just wonder if you were being referred, then almost the first local authority can be like.
Well, assuming you've got local connections to the first local authority as well. So I think in this case they've got local connections to local authorities. Okay. They've approached the first one. They've got a horrible, rubbish response, and on second thoughts, they would rather live in the second authority. So authorities can technically ask for the other authorities' cooperation, and what they're going to get told is, piss off. Basically, we're not helping you. So if you think it's hard for us to get councils to follow the law, it's just as hard for other councils to do the same thing. It's all quite funny, really, when it wasn't so desperately sad. So that third part of the question was what the consequence of being served a bailiff's warrant. Yes, you could be subject to court costs, but as I say, if you go to the LGO, you can get it back as part of that compensation. We did the question about the council has to provide affordable temporary accommodation for you. So if you're working, then they need to work out how much you can actually pay. And then this fifth one that came in the week, I'm a little bit perplexed by, but I'm going to try my best here. So basically, someone is disabled. I think they've been given the main housing duty, and they've effectively won a bid. So they won a bid on a bungalow or something. I'm not quite sure. They're expecting to get it, and then all of a sudden the council trumped, another family trumped them basically, and the council says, well, that family needed it more than you did. So and so this person's kind of, waiting again. Now, this makes me think of a case. There was I think it was Birmingham. Their housing allocation policy was found to be discriminatory, and it was actually they're actually trying to be good. So what they were basically saying is, it's good for families with children to have gardens, so we're going to prioritise properties with gardens for families. And what that didn't really take into account is that those where you've got, say, like adult disabled, multiple households with adult sort of disabled people in them, then they would fall foul of this because their properties were kind of given to someone else first, and there was challenges. Say it wasn't like done out of malice; it was just the council getting it wrong. So that's all I can say is that potentially, if it was me as a professional, I'd be FOIing the council's policy or looking at the website, in fact, because this bit should be on the website, and just seeing what it actually says. And potentially it might be that it's inadvertently discriminatory against people with disabilities, in that it's giving properties to families with children or something, when actually that's kind of preventing people with disabilities to get housed. So and once you've kind of figured out that's what's happening, then all I can say is you need to get a solicitor and kind of take that kind of thing down that avenue. So so it's 8:32. think we've done everything. Have we missed anything? I think we've got all the questions in the live chat. Oh, you're on mute, Will. Hold on. You're still on mute. There you go.
Now you can hear me?
Yeah, cool.
Yeah, just I won't go on too long, but I thought you might be interested to hear, or the people might be interested to hear, just a reflection of how bad local authority delays are at the moment, and also the court service, how bad the court service is. Because I had a case involved, I don't see why I shouldn't name the guilty council, which is London Borough of Bromley, although a sort of the review in that case was farmed out to the Royal Borough of Kensington and Chelsea, so they're as much to blame. So I requested a review last July. This is an 8-week time limit. The law says if they don't carry out the review in 8 weeks, you can appeal straight to the county court on the basis that they should have carried out a review. So on something like the 7th of September, I issue an appeal in the county court. Since then, I've been making complaints to the county court because they didn't issue it. And I made 2 complaints. I think I never got a response from the court service because their complaints procedure doesn't seem to involve replying. It involves sort of ringing up the court and saying, hey, somebody's made a complaint. And sometimes that works. But then this week, on sort of Monday, I got a letter from the council from Bromley saying, oh, we've completed the review from the 7th of July. No apology, no nothing. It's just a sort of, but then by a miracle, the following day, they issued the proceedings at the county court. So they both took, I think, 5.5 months so I think it's 5 months in September. But this isn't the only one. I've got a couple of cases where I'm waiting for the councils to issue, sorry, Central London County Court to issue appeals, and they've been waiting for months. So if anybody else out there is hearing about this, I'm going to look into it. If I get some time, I'm going to look into how to escalate the complaint because the court service complaints process is broken and the court is obviously broken. Local authorities, they never used to be this bad. I mean, they made bad decisions, but they did make decisions. But now it's routine. And I even got one from Kingston this week where I had to issue a second judicial review where they'd already agreed to provide temporary accommodation and then didn't do it. And their solicitor wrote back to me and said, sorry, I can't get any response out of them. And that's their own solicitor. So maybe it's really, really bad. So maybe it's quicker to go to the ombudsman now.
So I think the delay in review, that would be, I'm pretty sure that would be within the remit of the ombudsman to make a finding.
It would. I found it while you were talking about delays. I found one online actually where the council took 7.5 months to do a review, and at the end of it, they referred it back to the same caseworker to make another rubbish decision. So it delayed even longer, and they got compensation for that. It's yeah. I mean, it was.
To say how much?
Yes, I got it here. They got this is from 2015, and it involved. Let me see. It says proper timescales must be followed when deciding homelessness applications. And sorry, let me see. The figures are, yeah, the council had to pay £1,100 for stress and anxiety caused by the delays in dealing with her homelessness application, another £100 for the anxiety of not providing interim accommodation, and £250 for the time and trouble in pursuing the complaint.
Yeah, so I mean that is definitely better than a poke in the eye. So I think that's probably relevant to a couple of people who do kind of certainly that one about the 2 years, 3 month delay. There might be some actually more than £150 actually at stake here, so it's well worth just continuing along that.
Yeah, that's the end of my announcement anyway.
Yeah, no, that's interesting. I don't know anything about the kind of courts complaint service, but yeah, I think it comes down to it's London councils that are that broken, but I think everywhere is kind of worse than ever. I think, I said it before, just to anyone on the live stream, like once you get yourself sorted out, don't forget that experience and kind of do use it to inform the powers that be, and hopefully make things better for people coming after you, because otherwise no one's heard of this stuff. No one would believe. An average member of the public would not believe this is going on, that councils are breaking the law all the time. So yeah. Right, last question. We just got to come in very finally. So 4 children and I guess mum, one still in one hotel room, and 3-year-old child has been admitted to hospital 4 times this month. There is a mold in the room, overcrowding, conversation with doctors. So the fact that you're saying you're still in the hotel, that says that you've been in there a long time. So again, complain, chief exec, copy in your local councillors and so on. Mention the Awabi Ishaq case as well. Just kind of just pop that in there. That's not going to do you any harm. Just to kind of make the point that that's clearly not okay. And see what happens. Again, photos are really going to be really helpful here. So photos, evidence is the thing which really gets through to politicians, because they don't know anything about housing law. But if they see a photo of something that looks outrageous, they'll probably more likely take notice of it. So yeah, that's kind of it really. All right, guys. Well, so next Thursday we've got the event which is ending homelessness through local democracy. So we're going to be talking about some of these principles then. So we've got a councillor, we've got a local reporter. We've got a couple of other people who kind of have some interest or kind of background in this. So we're going to do this event. In terms of the live stream next week, guys, what is Wednesday or Friday better for you guys?
That's the 6th.
Yeah, so 6th or the 8th.
Wednesday's better for me, I
Me
think.
too.
Yeah, okay. We'll be back on next Wednesday then. And then you do tune in for the event as well. It should be good. So yeah, cool. All right, guys. I hope you found this useful. Yeah, hopefully it will be useful. And we'll see you next week. Keep the questions coming in on the comments on YouTube, and we'll